welcome back. This is what our criminal law learn with me. Y'all know Learn Out Loud series I've pretty much been doing. So tonight we're going to still continue to focus on actus reus or ex reus, but we're moving specifically into causation. And the question I wanted to the question I kind of keep coming back to is I pulled a vignette and I wanted us to kind of work on it together, and I want us to kind of always come back to the question of, did D, because D is going to be the person in our vignette today, did D really cause it, right? And that sounds like a simple question until you start looking at what like criminal law really means by cause, which is another reason why I was like, it seemed like y'all like these, so I came back to it, right? One thing I've been working through at the University of London material is that there are really kind of like two questions here, which is why I'm looking at my notes to make sure when I verbalize what I need to say today that I say it right? First we had the factual causation, but for, right? But for D's act or omission, would this consequence have happened, right? So the but for, we talked about that test in the last if you didn't catch that one, you can catch it in like 30 minutes, right? So the but for test, right? So the factual causation, but for D's act or omission, would this consequence have happened? Okay, but for. But even if the answer to that is yes, we're not necessarily finished, which is the next piece, right? We still have to ask about the legal causation. Is D's contribution sufficiently like connected to this particular harm that the law should actually hold D accountable for it? You know what I mean? And that's where it starts to get interesting. Okay? So that's where tonight gets interesting. That's where we're going to kind of jump into this new podcast, right? I threw us another podcast together with this in mind, right? So if somebody else contributes to the harm, right, what happens? What if somebody else contributes to the harm? What if medical treatment goes wrong, right? What if a victim has an unusual physical vulnerability? What if the victim makes their own decision after D's initial act? And that's another one that's super interesting. So we're going to listen to the podcast for that too. What if somebody reacts to the danger D created? Right? Because D created the danger. So what if somebody acts to that? Like what's the outcome then? We're going to work through the podcast and hear what it says, right? And eventually we're going to go to a bigger question, which is, when does something happen that actually breaks the chain of causation? So we're going to be talking about the chain of causation as well. I'm going to let the podcast get going. It's already rendered. I'm about to play it in a second. But I also want to also front load that what I'm using that AI-generated NotebookLM, which is a system discussion. That's what I'm basing it off of. And I'm using my course materials, some of my other materials that I had came along, some of my study notes and all of that as a foundation. I also put in some case law so we can make sure it's a little bit more specific and particular to what I needed to say and what I need to be studying right now, but also still want to make it a little fun, right? So I'm going to try to stop along the way as we hit on some of the questions so we can kind of have a moment to engage in the chat. But that's pretty much the focus of that. I'm especially listening tonight for the phrase substantial and operative cause. So that's what I'm listening for. I'm so excited that you guys are all here with me. Because one thing I'm already seeing is that D doesn't necessarily have to be the only cause when it comes to some of these situations. And there can be multiple things contributing to the same result. So the question becomes whether D's original wrongful conduct, right, is still doing enough causal work for us to attribute the result to D, right? So this is where it gets so interesting. We about to jump into this podcast. Y'all know how excited I am. There's something my material illustrates through cases like what was it, McKinney, and then there's later Smith. So once again, I told you I threw in some case law to help us as we navigate through this. Let me see what else I have on here real quick. So I'm not really like approaching tonight like I know every single answer. I really, like I said, I want us to stay together. I want y'all to learn with me. So this is the Learn With Me series that I've been doing. Hopefully y'all are enjoying it as I move through the material. I'm trying to understand patterns well enough that even if the exam gives me facts that I've never seen before, that I can like reason through them. And that's what I'm super excited about right now. Showing y'all my learn with me through the case studies. We almost jumped into another one, right? That's in the back. But let's see. So I'm gonna give y'all some facts, and then we're gonna kind of talk about them, and we're gonna listen to the Notebook LM. I see there's a few people in the chat. I'm gonna try to jump in through the computer. Let's see if I can jump on through here. And comment to you all. So I just want to say hey to everyone. Thank you so much. I see that you guys are giving me so much love in the comments. I'm going to start to play our notebook podcast. Once again, this one is 25 minutes. We're gonna jump in between. We're gonna, we're gonna talk. I'm gonna definitely go in and say hi to everyone as we're sitting here. But I'm super excited. I'm super excited to kind of have some conversations with you guys, to really kind of get into this. This is some really interesting information. And then once we hit certain points, like after the podcast is over, I can actually still go into Notebook LM and add any additional information. So if you guys stick along with this process, if you have questions at the end, we can actually upload them into Notebook LM and see what it says, so y'all can once again study with me. And once again, thank you all so much for your lovely comments in the chat. I really appreciate it. I always enjoy the engagement. So continue to engage in the chat. Communicate with me as the podcast is going. I'll communicate through the chat. And then once we get towards the end, once again, I can go back through, read any comments that we need to address, right? And then if it's necessary, I can also add it into Notebook LM. Once again, super excited. Hope you enjoy this podcast. We're going to start in 5, 4, 3, 2, 1.
Imagine you are standing in line at the post office. It's just a normal Tuesday.
Right.
And suddenly a guy cuts to the front of the line. An older gentleman calls him out on it, and the line cutter turns around and just punches the older man in the face.
Oh, man.
Yeah. So the man stumbles backward and bumps into an 89-year-old woman. She falls. She breaks her leg.
Okay.
She goes to the hospital, and like a few weeks later, she dies from a blood clot caused by the fracture. Now, the guy who threw the punch never even touched the woman. But the question is, did he murder her?
It is the ultimate legal puzzle.
Yeah.
Because we're so used to thinking of cause and effect as this really simple binary equation,
Right.
If you throw a rock, the window shatters.
Yeah.
But real life is almost never that clean.
Exactly. Real life is a Rube Goldberg machine. I mean, you flick a marble, it rolls down a ramp, hits a toy car, the car knocks over a candle, the candle burns a string, and an anvil drops on someone's head.
Yeah.
If you are the one who flicked the marble, are you responsible for the anvil?
Right.
So today, for this deep dive, we're talking about how society assigns blame when the chain of events gets just incredibly messy. And we aren't just memorizing cases today.
No.
We want to build a framework to actually reason through these complex causation problems.
This is where the law defines the concept of causation into two very distinct hurdles. To hold a defendant accountable, you have to prove two things. First, factual causation, and second, legal causation.
Okay, let's unpack this. Factual causation feels like it should be just straightforward physics.
It is. It's often called the but-for test.
Okay.
You simply ask, but for the defendant's action, would the victim have died as they did and when they did?
Right.
If the answer is no, then the defendant is a factual cause.
So if I set that Rube Goldberg machine in motion, I am the factual cause of the anvil dropping.
Yes, but let's say you set the marble rolling, but halfway down the ramp, an earthquake strikes the building.
Oh.
And the whole table collapses, and the anvil falls. You aren't the factual cause anymore.
Because my marble didn't do it.
Exactly, the earthquake did. There's a classic case that illustrates this perfectly, a case called White. A man decided he wanted to inherit his mother's money early, so he slipped poison into her evening drink.
Okay, pretty clear-cut malicious intent there.
Very. But before the poison could actually take effect and kill her, she suffered a completely unrelated massive heart attack and died in her chair.
Wow. So the earthquake hit the table.
Exactly. When you apply the test, but for the poison, would she have died in that exact moment?
Yeah.
Yes, she would have. The heart attack was happening regardless. So the man was certainly guilty of attempted murder, but he was not the factual cause of her death.
Because the physical chain of physics just wasn't there.
Right.
But wait, what if someone is already dying? Let's say the Rube Goldberg machine is already in motion, completely on its own, and I just reach in and flick a gear to make it run faster.
Okay.
I didn't invent the danger, I just sped it up. Am I
Sure.
still a factual cause?
You are. Yeah, you don't have to be the sole cause of death, you just have to accelerate it. We see this in a profoundly tragic case called Dyson. A father severely beat his child. When the child was finally taken to the hospital, the doctors discovered the child was already suffering from advanced meningitis.
Oh,
In fact, the meningitis was terminal. The child would have died very soon, regardless of the assault.
so the father's defense strategy was probably something like, look, I didn't kill the child, the disease did.
Right. But the court firmly rejected that argument. We're all technically dying. Murder is, in a strict legal sense, just accelerating the time of someone's death.
Wow.
Because the severe beating made the child die hours or days earlier than the disease would have naturally dictated. The father was a factual cause of death.
Which brings us back to my post office scenario at the beginning. That's a real case too, isn't it? The Mitchell case.
It is. The defendant punched the man who fell on the elderly woman who broke her leg and died of an embolism.
I mean, factual cause seems almost too easy to prove there. But for the punch, the man wouldn't fall, the woman wouldn't break her leg, the clot wouldn't form. Factual causation is just like a giant net that catches anyone who played even a microscopic role in the timeline.
Precisely. Which is why factual causation alone just isn't enough.
That's so
Purely scientific, doesn't care about fairness at all.
great.
That is why we have the second hurdle, legal causation.
Right.
Sometimes it's called proximate cause.
Yeah.
This is the moral filter.
The moral filter.
Yeah, this is where the law steps back and asks, is it actually fair to blame this person for the final outcome?
I want to test this moral filter. Think about this scenario for a second. Let's say a man commits a horrific sexual assault against a young woman.
Okay.
The woman's father finds out about the assault. He is so enraged by the trauma inflicted on his daughter and by his own twisted sense of family honor that he actually murders his own daughter.
Oh, wow.
Now, the assaulter is absolutely a factual cause of her death. But for the assault, the father wouldn't have been enraged and she wouldn't have been killed.
That's a perfect stress test for the doctrine.
Yeah.
Factual cause. Yes. Legal cause. Absolutely not.
Because even though I want to see the assaulter punished severely for his crime, calling him a murderer feels like we are erasing the father's agency.
Exactly.
It just lets the father off the hook for a conscious evil choice.
That is the core of legal causation. It is fundamentally a moral judgment about culpability. The court is deciding if the final outcome is just too remote from the defendant's original conduct.
Right.
The father made a free, deliberate, and informed choice to commit a murder. That choice severs the moral connection to the original assaulter.
Okay, that makes sense.
To establish legal causation, the law requires the defendant's action to be two very specific things. First, the harm has to be connected to the defendant's specifically wrongful conduct.
Okay, let me see if I can puzzle that one out. So the act has to be inherently criminal.
Yeah.
Because if my criminal act was totally trivial, like I illegally parked my car in a red zone, and because my car was there, a cyclist had to swerve and a piano fell on them, I'm a factual cause, but my wrongful conduct, a parking ticket, isn't morally connected to a crushed cyclist.
That's a great way to look at it. Let's use a more intense example, though. Imagine an armed bank robbery.
Okay.
A robber is holding a teller at gunpoint. A totally innocent customer decides to play hero, sneaks up, and grabs the robber's gun to wrestle it away.
Oh boy.
In the struggle, the customer's finger slips into the trigger guard, the gun goes off, and another teller is killed.
The innocent customer's hand pulled the trigger, so they are the factual cause.
Yes, but their conduct wasn't criminally wrongful. They were trying to stop a violent felony. The armed robbery itself is the wrongful conduct that created the lethal environment.
I see.
Therefore, the law looks past the customer and holds the bank robber as the sole legal cause of the teller's death.
Okay, so the conduct must be wrongful. What is the second requirement?
The defendant's contribution to the final harm must be substantial and operative. It cannot be just a trivial footnote in the timeline. There's a case from 1865, Benge, that cemented this. Benge was a railway foreman. He misread the train timetable and ordered his crew to take up the tracks right when a train was scheduled to come through.
Oh no. A recipe for disaster.
A total disaster. The train came, couldn't stop, and killed several workers. Benge was charged with manslaughter.
Okay.
His defense in court was essentially pointing the finger at the train driver, saying, If the driver had been keeping a better lookout, he could have hit the brakes in time. He's the cause, not me.
But the only reason the driver even had to hit the brakes was because Benj ripped up the tracks.
Exactly. The court said that even if the driver's failure to look out was a competing cause, Benj's catastrophic misreading of the timetable was still a massive, substantial reason the men were dead.
Right.
It wasn't trivial, it was heavy.
But that raises a really difficult question. What happens when two massive life-threatening causes collide in the same body at the exact same time?
Okay, interesting.
Like, let's say you put a victim in the hospital with a wrongful act, but a completely natural, massive medical emergency happens to them simultaneously.
You're talking about the doctrine of multiple concurrent causes. And the case of McKechnie is the perfect illustration of this.
Okay.
The defendant brutally attacked an elderly man, causing severe head injuries. The man was rushed to the hospital and fell into a deep coma.
Right.
While he was in the coma, the doctors ran scans and discovered something terrifying. The man had a severe, life-threatening duodenal ulcer,
Oh,
and it was about to burst. But here was the ultimate medical catch-22. To save him from the ulcer, they needed to operate immediately. But because of the severe brain trauma and the coma caused by the beating, putting him under anesthesia for abdominal surgery would have killed him on the table.
wow. Their hands were completely tied.
Completely tied. They could only watch the monitor. Eventually, the ulcer burst, and the man died.
God, that's awful.
The autopsy showed he died of a burst ulcer, a naturally occurring disease. So what's fascinating here is the defendant appealed his murder conviction, arguing, I didn't give him an ulcer. The disease killed him.
But the only reason the doctors couldn't cure the disease was because of the brain injury.
Yes. The court ruled that the initial beating was still a substantial and operative cause. It was still heavy.
Right.
It was still dictating the
Substantial and
terms of the victim's survival by preventing life-saving surgery. As long as your original wrongful act is still heavily influencing the outcome, you don't get to pass the blame to a coincident disease.
Okay, so we've covered natural diseases, but let's talk about other people jumping into our Rube Goldberg machine. What if the person disrupting the timeline is an independent third party?
This brings us to the concept of intervening acts, or novus actus interveniens, a new intervening act.
Right.
And the general rule is that third-party reactions to a danger you create won't break the chain of causation if they're foreseeable. Take the Paget case.
Paget is the human shield case, right?
Yes. A deeply disturbing scenario. Paget was cornered by armed police on a dark balcony. He grabbed his pregnant girlfriend, held her in front of him as a human shield, and started firing a shotgun at the officers.
In the dark.
In the dark. The police, returning fire in self-defense, tragically hit and killed the girlfriend. Paget was charged with her manslaughter.
And I bet he tried to blame the cops.
Oh, he did. He stood in court and argued that the police officer pulled the trigger, so the police officer was the legal cause of death.
But the officer wasn't acting independently. They were basically a forced gear in Paget's machine.
That is exactly how the court viewed it.
Yeah.
The police officer's action was not a completely free, deliberate, and informed independent choice.
Right, they had no choice.
Exactly. It was a forced, instinctual reaction to a deadly threat created entirely by Paget. It was reasonably foreseeable that if you shoot at cops, they shoot back.
Yeah.
So the chain of causation stretching from Paget to his girlfriend's death remained perfectly intact.
Okay, I follow the logic there. The police were forced to react. But let me push back hard on this next one. What about doctors?
Okay.
Let's say I stab someone in the chest. An ambulance arrives. The medics load him onto a stretcher, but they slip and drop him on the pavement.
Ouch.
Yeah. Then they get him to the hospital, and a doctor gives him terrible CPR, pressing down so hard on his chest that it actually worsens the puncture in his lung. Surely I am off the hook for murder at that point. The medical care wasn't just bad, it actively killed him.
You would think so, wouldn't you? You just described the exact facts of the Smith case.
Wait, really?
Yeah. The victim was stabbed, dropped by medics, and given artificial respiration, which is universally known to be terrible for a punctured lung.
Yeah.
And the court looked at all of that and still held Smith, the stabber, as the legal cause of death.
How is that possible? The medical team practically finished the job.
Because of something called the autopsy test. The court reasoned that if, at the exact time of death, the original wound is still an operating and substantial cause, then the death is the result of that wound.
Oh.
The knife wound was still bleeding, was still destroying his lung. The incredibly bad medical care didn't invent a new injury, it just failed to fix the one Smith created.
So doctors get this massive, impenetrable shield.
They really do. And the rationale becomes even clearer when you look at a case involving a long delay, like Cheshire.
Okay.
In Cheshire, a man was shot in the abdomen and leg. He was taken to the hospital, and the surgeons performed a tracheotomy to help him breathe. Weeks went by. Weeks. The bullet wounds were actually healing well. But the victim suddenly died because his windpipe narrowed a rare complication for the tracheotomy that the doctors negligently failed to diagnose in time.
Weeks later, the gunshot wounds were healing, and the shooter is still on the hook.
Still liable.
Wow.
The court in Cheshire laid down a very strict doctrinal threshold. They said medical treatment only breaks the chain of causation if it is so independent of the defendant's acts and in itself so potent in causing death that the contribution made by the defendant's acts could be regarded as insignificant.
Insignificant. Basically, the medical error has to be so astronomically reckless that it completely overrides the original crime.
Exactly. And we really only see that threshold met in one major case, Jordan.
Okay, what happened there?
In Jordan, the victim was stabbed. The wound was mostly healed, but the doctors administered a specific antibiotic, terramycin.
Right.
The patient had an allergic reaction. The doctors noted the allergy in the chart.
Good.
And then the next day, a different doctor gave him another massive dose of the exact same antibiotic, along with wildly incorrect IV fluids. The patient's lungs became waterlogged and he died.
Okay, that's not a clumsy rescue. That is just poisoning someone.
The court described the treatment in Jordan as culpably wrong. It was so bad it became a brand new, overwhelming cause of death.
Yeah.
The stab wound was just a historical background at that point.
I see the tension here. The doctrine protects doctors because emergency rooms are chaotic, high-pressure environments. There's a clear policy reason. I mean, the law does not want a criminal to benefit just because medical science tried and failed to save a life that the criminal put in jeopardy in the first place.
That is the exact policy.
Yeah.
You created the chaos, you don't get a discount because the rescue attempt wasn't perfect.
So if doctors get this massive shield because they are trying to save a life, what happens when the person disrupting the timeline isn't a doctor, but the victim themselves? Because victims aren't just passive objects rolling down a ramp, they make decisions.
And this is where the doctrine gets highly nuanced. The law divides victim agency into two very distinct categories: who the victim is versus what the victim chooses to do.
Okay.
Let's start with who they are. This is governed by the thin skull rule. It dictates that you must take your victim as you find them.
Meaning if I punch a guy and he happens to have a literal abnormally thin skull and dies, I can't say, well, a normal person would have survived.
Correct. But it goes beyond physical biology. Look at the Blau case. The defendant stabbed a young woman in the lung. She was rushed to the hospital and the doctors told her she needed an immediate blood transfusion to survive.
Okay.
However, she was a devout Jehovah's Witness. Her religious beliefs strictly prohibited blood transfusions. She refused the blood and she died of blood loss.
I can already hear the defense attorney's argument. She chose not to get the blood. She basically chose to die. That breaks the chain.
That was exactly the argument. But the court firmly struck it down. They ruled that a person's deeply held religious beliefs are a core part of who they are.
Wow.
You have to take your victim as you find them, soul as well as body. Her refusal didn't break the chain because the stab wound was still the bleeding operating cause of her death.
Here's where it gets really interesting for me. I can accept that refusing treatment because of your identity leaves the chain intact. But what if the victim takes active physical steps to escape? Let's say I threaten someone and they run away and get hurt. Is that on me?
It depends entirely on whether their reaction was a foreseeable response to your threat. Let's compare two contrasting cases here. Roberts and Williams and Davis.
Okay.
In Roberts, a young woman was a passenger in a moving car. The driver suddenly began making unwanted sexual advances, trying to pull her coat off.
Terrifying.
In sheer panic, she opened the door and jumped out of the moving car, sustaining serious injuries.
A total fight or flight response.
Exactly. The court ruled that jumping out of a car to escape a sexual assault is a completely foreseeable natural reaction to being trapped. The chain of causation remained intact. The driver was responsible for her injuries.
And I'm guessing the other case goes differently.
Very differently. In Williams and Davis, a hitchhiker was picked up by two men. During the drive, the man allegedly tried to rob him of his wallet.
Okay.
The hitchhiker opened the door of a car moving at 30 miles per hour, jumped out, struck his head, and died.
Wait, he jumped out of a fast-moving car over a wallet.
That's the crux of it. The court held that his reaction was daft. It was wildly disproportionate and totally unforeseeable.
Huh.
Fleeing a simple robbery by risking certain death in traffic was so irrational that it constituted a completely new independent act. It broke the chain.
Wait, I need to pause here because this feels like a massive doctrinal contradiction.
Okay.
A victim's highly unusual religious belief that leads to her bleeding to death leaves the chain intact. The stabber is a murderer, but a hitchhiker's panicked escape from a robbery breaks the chain, and the robbers escape a manslaughter charge. Why the discrepancy?
It's a brilliant observation, and it highlights the tension in how the law views free will. Blau is about pre-existing conditions. You don't get to choose your victim's vulnerabilities. But Williams and Davis, along with cases like Kennedy No. 2, where a victim voluntarily injected himself with heroin that the defendant merely handed to him, those cases are about a victim's free, informed, and deliberate actions.
So there is a threshold of rational adult agency.
Yes, if a fully rational adult makes a voluntary independent choice that is either wildly disproportionate to the threat or completely free of coercion, like choosing to inject drugs, the law treats that as a brand new Rube Goldberg machine starting up, a new domino falling all on its own.
Which naturally leads to the absolute hardest scenario to untangle. What if the victim's choice is to end their own life? How does the law handle the tragedy where a victim survives an assault, but the psychological trauma is so severe they later commit suicide?
This raises an important question about mental trauma and temporal distance. It really is the frontier of causation doctrine. It forces us to ask if extreme trauma can essentially erase a victim's free will. We have to compare two critical cases here, Dhaliwal and Wallace.
Let's start with Dhaliwal.
In Dhaliwal, a woman tragically took her own life after enduring years of horrific systemic domestic abuse by her husband. The prosecution attempted to charge him with manslaughter, arguing he caused her suicide. But the court had to dismiss the charge. They held that general life misery, even if it is entirely the fault of an abusive partner, doesn't directly cause suicide in a strict legal sense.
So because the abuse was a general atmosphere rather than one specific immediate physical attack that pushed her out a window in a moment of panic, the causal link was too stretched.
Exactly. The law views a decision to end one's life as an independent choice if it's born from general despair over time. But then you look at Wallace, and Wallace challenges everything we just discussed.
Wallace is the acid attack case, right?
Yes. The defendant threw a container of concentrated sulfuric acid over her former partner while he slept. The injuries were apocalyptic.
Oh,
He
God.
was left entirely blind, paralyzed from the neck down, and in agonizing, unceasing pain. 2 years later, 2 entire years, he traveled to a clinic in Belgium where euthanasia is legal and voluntarily ended his life.
2 years later, the physical act was over. The man made a conscious, medically assisted choice in another country. How can the law possibly connect the acid attack to the death as a murder charge?
Well, the trial judge agreed with you. The trial judge threw the murder charge out, ruling that the chain was obviously broken by the sheer passage of time and the victim's clear voluntary choice to undergo euthanasia.
Makes sense.
But the Court of Appeal brought the charge back.
Yeah.
They reversed the ruling.
On what grounds?
They ruled that a jury must be allowed to decide if the original horrific act made a significant contribution to the death. The Court of Appeal recognized something profound. The victim's choice in Belgium wasn't a free, independent life decision.
Oh,
It was a direct, inescapable, and visceral response to the catastrophic physical and psychological prison the defendant trapped him in.
wow. The extreme agony basically bridged the 2-year gap. The acid attack was still the operating cause every single day.
Exactly. The severity of the trauma meant his choice wasn't a novus actus interveniens. It wasn't independent.
This is fascinating, but it's also incredibly dense. We've gone from poison and post-office lines to burst ulcers, negligent doctors, and assisted suicide.
Yeah, we have.
So what does this all mean? If I want to actually use this, I need to see the framework in action. Let's test it. Let's build a hypothetical right now and run the ACEP framework from the legal doctrine on it.
I love it. Give me a scenario.
Okay. I am on a low footbridge. I get into an argument with a guy and I aggressively push him. He falls off the bridge into a shallow river and breaks his leg. He goes to the hospital. A doctor sets his leg but carelessly gives him a pain medication that is clearly marked on his chart as a deadly allergy.
Oh boy.
The guy starts having a severe reaction. In a total panic, delirious from the reaction, he runs out of the hospital room, trips down a flight of stairs, breaks his neck, and dies. Am I a murderer?
Okay, let's walk the 8 steps. If we connect this to the bigger picture, step 1. Are you a factual cause? Yes. But for you pushing him off the bridge, he wouldn't be in the hospital, he wouldn't get the drug, he wouldn't fall down the stairs.
Right.
Step 2. Is the consequence attributable to your wrongful conduct? Yes. Pushing him off a bridge is an illegal assault.
And step 3 is substantial contribution. Breaking his leg isn't trivial. It put him in the hospital.
Exactly. But here's where it gets tricky. Step 4. Is your original conduct still operative? Is the broken leg heavily influencing his death? Not really. The broken leg is just background context at this point.
Okay.
Step 5. Has another cause intervened? Yes, 2 actually. The doctor's medication and his own running down the stairs.
So step 6, are those intervening causes independent of my conduct?
Right. The doctor's mistake is independent. The panic running is a reaction to the doctor, not a reaction to your push.
I see.
Step 7. Are those intervening causes sufficiently powerful to make your original push insignificant? Yes. Giving a known deadly allergen is palpably wrong, like the Jordan case. It overwrites your broken leg.
Wow.
And finally, step 8. What authorities support this? You would argue using Jordan to show the medical negligence broke the chain, and maybe Williams and Davis will argue his panicked run was an independent act.
Conclusion, I am guilty of assault for the push, but I am not the legal cause of his death. The Rube Goldberg machine was hijacked by the doctor.
You nailed it. You just applied the framework perfectly. It takes the mystery out of the doctrine and lets you track the moral culpability step by step.
That is incredibly satisfying. But before we wrap up, I want to leave everyone with one final thought, something to really chew on that wasn't in our 1980s or 90s case law.
Okay.
We spent this whole time talking about human interventions, doctors making terrible mistakes, police firing weapons, victims jumping out of cars. But we are rapidly entering an era where AI and autonomous machines are going to be making these timeline-altering decisions.
Oh, yeah.
AI is already rendering medical diagnoses. Autonomous vehicles are reacting to dangers on the road. If I push someone into the street and a self-driving car suffers an unforeseeable algorithmic glitch and runs them over, how will the courts handle that?
That's a great question.
Is a machine's glitch a novus actus interveniens? Can a string of code be an independent third party that breaks the chain of causation? Or do I still take my victim as I find them in a world run by algorithms? Something to ponder until the next deep dive.
Interesting, right? I got some nuggets. I don't know about y'all, but I definitely got some nuggets. Do we have any questions we might want to put into not ChatGPT? What's the name of this one? NotebookLM. Do we have any questions we might want to ask while we're right here? I found this quite interesting, right? I found it quite interesting. So as far as the formula, I typed it in there. The formula being, at least so far, right, those 8 pieces. But for, right, X. Whatever the X may be in the situation, right? But for this particular vignette, we have but for D, right? Because D is the person we've been referencing in all these scenarios. Then we move to wrongful conduct. What is the wrongful conduct that they engage in, right? This actual act or omission in some situations, right? The substantial contribution. The next thing would be, is it still operative? The next component would be intervening cause, right? The intervening cause. Is there an intervening cause? The next piece would be, is it independent? The next step would be, is it powerful enough to make D's contribution insignificant? All right. We're going to dive in again because I have another set of questions. So I'll be doing another Learn With Me Live probably around 10 o'clock. So about 2 hours. I might move it up 1 hour, but more than likely it's going to stay at 10 o'clock. Going to give it time, the system time to render the answers to the questions I'm about to put in. But yeah, this has been a really good live. I really appreciate you guys being in the chat. I appreciate you all engaging with me, staying here with me, learning with me. Because what I'm learning out loud, I'm learning with you guys. This is very interesting material. It always just makes me interested, because the question is, did D really cause it, right? And there are so many factors that are built into the situation that makes it not just a straightforward answer like we always kind of like to think. I think the way that the law looks at it versus like sometimes how we're looking at it, we're like, oh yeah, X, Y, and Z, right? But when we start to look at it through this lens, sometimes it's not as straightforward. And that was like one of those things I wanted to kind of somewhat demystify as I was studying and as I'm learning. Um, Sometimes the way that we've been looking at things might not necessarily be the way that the law, the way the prescriptive nature of it is absolutely looking at things. So it's just been very interesting as I've been going through this material, and I thought you all might be interested in learning with me. So once again, it's Legally Everywhere with Child. We legally everywhere. We looking into everything. Hopefully you enjoyed this live, because once again, we kind of got to dig into what did D really cause it, right? Um, and we were able to move through a couple of case laws. We were able to move through a few vignettes. We were able to ask some questions, do some true and false. We even had a quiz that I was able to put on here. Trying to get better with moving around with these live features. But I've had fun, and hopefully you all have enjoyed yourself and you are enjoying being on this live. I will hopefully see you in the next live, whether that's the one I'm doing at 10 o'clock or if it's another one that I'm doing on this channel. But I hope to see you. And what this is Legally Everywhere with Child. We Legally Everywhere doing, looking into everything. If you like what you see, please like, comment, share, subscribe. But I'm always excited to see the levels of engagement. So definitely feel free to put something in the chat. Definitely put something in the comments. I personally love that. But just for the sake of YouTube, I would appreciate if you're able to share, comment, and eventually subscribe so that we can build out this community. I'll see you all in I'll see you in the next video. Until next time, see you.